This is a video recorded review for the second test. Chapters 12, 13, 14, 15, and 16 that will be on your second exam. I am doing this by video because in the past the live in-room reviews tend to go pretty fast, and I think a lot of you don't keep up to speed. So we're going to put this in a video format so you can listen to it and go through it a couple of times if necessary to help prepare for the test. The second test has a similar format to the first test, and some of the things I will tell you I have told you before. Hopefully you will take this guidance and make good use of it. A couple of general themes on preparing for the test. Contract is a 6-hour, 1-year course in law school. It has a ton of content. And it basically comprises almost half of our business law course. But even as much time as we can allocate to it, we are dealing with a very, very large, broad subject, and it tends to reduce itself to definitions. In class, I try to use stories and anecdotes and examples to illustrate how the law works. Now, this lecture is to be used in conjunction with and not in lieu of the textbook. Now, I know in college, personally, I came to class consistently and listened to lectures and wasn't real big on reading the book because oftentimes the book was dry as dirt. That's not going to be a successful strategy. Now, can you come to class, be attentive, take notes, pay attention to the PowerPoints, and maybe end up with a B in the class? Yes, you can. However, if you really want to get into the top 20% of the scores where the A's are to be found, you need to spend some time on the textbook. So the purpose of the lectures is to give you the analytical tools to read the textual material and apply one to the other. So I know the book is dry. I'm well aware of that. I've read it a gazillion times. I know dry when I see it. If you think this is dry, read the bankruptcy code sometime. So I know it can be a little bit dry. It's not exciting reading. It's not Harry Potter, and I'm very well aware of that. Having said that, the chapters are fairly short. The material we're in now is definitional. It's not complex. And so it's just a matter of disciplining yourself to spend that time in the book, because the true-false multiple choice questions are derived from questions provided by the authors of the textbook. And sometimes some of the detail and the inherently tricky nature of some of that material really will only be sorted out by a certain amount of time with the book. So, read the book. Now, having said that, a little bit about the format of this test. This test is going to be a little bit more true-false multiple choice and a little bit less subjective. As I go through the review today, I will tell you the areas of emphasis on each chapter. The test is 100 points, and this will be 70 true-false multiple choice and 30 completion short answer fill in the blank. Now, the true-false multiple choice, as in the first test, are divided evenly among the chapters. That means, I'm get my math right here, 7 true-false for each chapter and 7 multiple choice for each chapter. Looking back through the tests, many of you, the worst performance you have is on the true-false. That is an indicator to me if people haven't spent enough time with the textbook or speed through the exam. Again, let me give you that generalized information. Pretend I'm Yoda talking to Luke Skywalker in the hut. Read the questions out loud to yourself silently. Slow down. Am I trying to trick you? Nope. Are you pretty trickable? Yep. So read the questions out loud to yourself silently. That will slow your brain down from thought speed to speech speed, and you won't make speed errors. And I see speed errors repeatedly. There's a few of the true and false and a few of the multiple choice. It can be tricky if you're speeding through it. Don't do it. If I tell you something's on the test, guess what? It's on the test. Learn it. So I'm going to go through now. I have the book right here in front of me and go through some of the chapters in order. And what I'm talking about now gives you direction on your rereading, and it also lets you know where to focus your attention on the PowerPoints and the lectures as far as the completion short answer. To start with, 6 points automatically in the bag, don't pass, go, are the 6 elements of a contract. You need to know them. Trick me, surprise me. Let me have one class first before I die of old age that everyone gets all 6 elements of a contract. An agreement between competent parties with genuine assent, supported by consideration for a legal purpose or object, and in a form required by law, if any. I don't need long answers. It can be agreement, competent parties, genuine assent, consideration, legal purpose, legal form. All right, I'm going to take a look at the book. Chapter 12 on the nature and classes of contracts is very definitional. And I will tell you areas where you will be held accountable for definitions. Now, if I skip an area, that doesn't mean it's not on the test. It simply means I won't be asking you what are the 3 of these or the 4 of those. Does that make? I hope that makes sense. When we get to the material on formal contracts, there's 3 formal contracts listed. I will not ask for a list of formal contracts. However, you will see a question. A question might say, a recognizance is a form of formal contract. Well, the answer to that would be true. So you need to read through and see what they are. When we deal with express and implied contracts, I follow my material from class more than the book. So I talk about contracts that are express, implied in fact, which are both contracts, and the third type are contracts implied in law, which are not contracts, they are quasi-contracts, the evil and mysterious quasi-contract that looks like a contract but isn't really a contract. Will there be a question directly on that point? Yes, there will. I will ask you, is a quasi-contract a contract? And the answer is nope, it's not. When we get to the void, voidable, and valid, I frequently ask that, and I use what I had on the PowerPoint in class, which is all 4 elements: valid, voidable, void, valid but unenforceable. Know what executed and executory are and the difference between bilateral and unilateral. The option we talk about, really we flesh the option out excuse me, more in Chapter 13 than Chapter 12. In Chapter 13, we go through the definitions of the option as well as the firm offer, both of which you're responsible for. Remember, the option is the kid buying the Mustang and putting the $100 down with the dealer to hold it while he tried to talk his dad into the money. Quasi-contract is mentioned. It will appear in some of the true-false multiple choice questions. Read the material found on page 249 and 250 in your textbook. You will see this with a fair amount of frequency in the true-false multiple choice questions. All right, moving over to Chapter 13. Chapter 13, we have, remember in Chapter 12, we talked about the farmer with the ceramic horse and the living horse. The ceramic horse was the subjective intent. Here's the declaratory sentence Answer. Objective intent is what you use for contractual formation. Do you need to know that? Yes, you do. You need to know that advertising is a class, is an invitation to negotiate. Remember, I gave you some variations on that with the guy going through the store to get the mink stole, that sort of thing. Don't be distracted or led astray by that. If I ask you a question about advertising, advertising is an invitation to negotiate. So if you find the mismarked coat on the rack that's a $250 coat and it's marked $25, you take it to the checkout. The cashier is not obligated to accept $25 for the coat. That means you're the offeror. I want you to know the elements of an offer. We talked about those in class. Go with the two. The two are legal definite terms and communication. Now, your text talks about exceptions to the rule of definiteness. There's 3 or 4 pages on this, and it will not be on your test as a list. The definiteness was like incorporation by reference. Now remember, I told you in class, incorporation by references, that's a dirty trick because that little concept shows up not only on your second test, but on your third test. Remember, the key there is incorporate. That's the verb. That's what we use. So you will see some true, false, and multiple choice in this area, no lists. Now I had on a PowerPoint a listing of ways that you terminate an offer, which is revocation, rejection, counteroffer, death, destruction of subject matter, etc., and so on. I would take a look at those in conjunction with the text. Remember that each one of them terminates an offer. However, they will not be on your exam as a list. Don't memorize them. You need to know what a firm offer is. You need to know what a firm offer is, and the firm offer is provided for under the Uniform Commercial Code. Now, acceptance is pretty straightforward. I want you to know the rule on silence is acceptance. I'm going to refer to some paragraphs. We didn't talk about this in class. There's one short paragraph in the textbook. Read through that. That's on page 273. And the mailbox rule. There will be at least one mailbox rule question on your exam. Now, I told you that although many of you come from families that mom and dad go down, drink cheap wine, and then bid too much on class projects, although it might be hazardous to you, the whole process of auctions, I don't cover it in my exam. So the auction paragraph on page 276 is not included in the test. Okay, chapter 14 is the most content-rich chapter that we have. It really has 2 sections, capacity and genuineness of intent. So if we look back at our 6 elements of a contract, you had number 2 was competent parties, number 3 was genuine assent. Both of those are covered in chapter 14. I will not ask for a definition of capacity. Remember, we have the picture of the PowerPoint with the guy with the confused look on his face, and he said, well, what's capacity mean? And that was the traditional rule of the nature, the purpose, and the effect of the transaction. No list. You will not have a list on status, on factual status or legal incapacity. I gave examples on that. Status, of course, was like minority, being a kid under 18. Factual was being just having something wrong with you where you couldn't think. That's just a fact. You couldn't do it through drugs or alcohol or a car wreck or disease or accident of birth or old age, just so you can't process a contract. The third of those was adjudicated. Grandma had a lot of money. She has Alzheimer's. We had to take her in. and get a guardian appointed for, then you're legally incompetent. So you'll see those in true, false, multiple questions, but not as a list. You need to know the rules about minority. The minor has to pay the reasonable value of necessaries. That's a minority rule. And secondly, you need to know the rule about the difference between the innocent and the misrepresenting minor. Remember, misrepresenting minor is the person that has fake ID. I know none of you have ever heard of fake ID, but that's fake ID, is a misrepresenting minor. Okay, when we get over into the genuine of assent, the book breaks this out kind of in an unusual fashion. They call it mistake, deception, and pressure. Really what you have is basically two under each. Law calls it accident, mistake, fraud and misrepresentation under deception, and duress and undue influence under pressure. Now, you will not see those on this second test as a list, but you will see them, lots of questions about content and what goes into it. So you need to know there's 4 different types of mistake, but the kind of mistake that you really need to know, or the one that makes a difference, is a mutual mistake of fact. I refer to that frequently as the cow case. By the time you're seeing this video, we will have gone through a case dealing with a polled Angus cow, and so that's the cow case. And that's what you need to know is a mutual mistake of fact. Deception is broken down into fraud and misrepresentation. With fraud, you need to know the requirement of subjective intent. And if you look through the PowerPoints, we have the picture of the old Yugo, and I'll tell you a story about somebody buying a Yugo. Okay, so that's excuse me, that's an example of subjective intent. There is a definition, a long common law definition in the PowerPoints that has 9 elements to it. You will not be responsible for that. You're lucky I'm getting old, because I used to make students memorize that back in the olden days. But you do need to know what goes into fraud. So there's a fair amount of true, false, multiple choice questions on the issue of fraud. Read the materials in the text carefully. Now, when we get over into pressure, pressure breaks down into 2 classes. One of those is undue influence, and the other is duress. You need to know that undue influence goes along with a fiduciary relationship. And I tell you the story in class about Anna Nicole Smith marrying the 90-year-old old codger, and all of the lawsuits, concluding going to the Supreme Court, that flowed from that. So here we have a 26 or 7-year-old, basically stripper, marrying an old billionaire, and ending up with a bunch of money. So the issue there was undue influence, and undue influence requires a fiduciary relationship. Duress, the PowerPoint picture shows someone with a pistol to their head. That requires threats of violence, physical pressure, or sometimes today, economic pressure. The chapter 15 on consideration is a little shorter, kind of tricky. Not a bunch of lists from this chapter. Your emphasis here on chapter 15 should be on the true, false, and multiple choice type questions. You need to know not the elements or definition of consideration. I have consideration. PowerPoint definition will not be on the test, but you do need to know what kinds of things go into consideration, and the biggest thing you need to know about is that it's bargained for, and that means if. Know what a gift is. A gift is a promise not supported by consideration. You need to know the rules on adequacy, and you need to know about forbearance. Forbearance is to refrain from doing that which you have a legal right to do, and it is a form of consideration. Illusory promises, read through it. It's not going to be on the test as a list. Now, where you will see some detail is when we get over into pages 310, 311, and 312 are about exceptions to the requirement of consideration. It's listed as the good faith adjustment, compromise and release of claims, part payment checks, and composition of creditors. I will have talked about those at some length in class, but you will not see them on the test as a list. When I say they're not on the test on the list, they're still very likely to be on the test as the subject of a true, false, or multiple choice question. Now, when we get over to the exceptions to the requirement of consideration, that's found on page 314. There's 3 listed. Charitable subscriptions, that means a pledge to Gonzaga. Uniform Commercial Code, one of those is the firm offer. Okay, under the code, no listing. I will not ask for a listing of those 3. When you get to promissory estoppel, we talk about it now. That's the Lamborghini case, Lee Iacocca and the P140 Lamborghini. I will not ask you for a definition of promissory estoppel, God forbid. However, you need to know a couple of things. Number one, it's a substitute for consideration. It's not a form, it's a substitute. And the way you tell that it's not consideration is that little magic 2-letter word, if, isn't there. So you will see a number of promissory estoppel questions. Read and reread that chapter. Okay, chapter 16, legality and public policy. This is kind of a, how can I describe chapter 16? Well, I'll tell you how you describe it. It's 2 chapters that were compressed into 1. So we know that contracts have to be legal. So they talk about the concept of what constitutes legality. I want you to know, and I'm going to direct your attention to page 322. I want you to know the doctrine on in pari delicto, which you will see on the test, and will be discussed with some enthusiasm in class. Unconscionability. You will see unconscionability on the test. I repeat, you will see unconscionability on the test in the subjective area. Now, we have 3 things, and I will beat this to death in class, and it's in a PowerPoint. You have a doctrine, unconscionability. You have a provision in a contract. We call it an unconscionable clause. And we have a contract that contains an unconscionable clause that's called a contraction of adhesion. Adhesion, and it's not because it's sticky. It's a legal meaning of adhesion. So, those 3 all have different meanings, and it's set out in the PowerPoint. I ask a number of questions on unconscionability. Keep those straight, because close is not good enough. We're not playing with hand grenades. All right. Contracts contrary to public policy, read through that. Remember, wagers are not enforceable. Those are you getting ready to vote or bet on sporting events. Gambling is not legal except where it's legal, like tribal casinos. Now, when we get over into regulation of business with licensed callings or dealings, we'll talk about this in class. There's 2 ways of looking at it. If the legislature passes a license that's just intended to raise revenue, then contracts that violate that are still enforceable. If the licensing provision is to ensure competence, then that contract will be void. For example, I have a law degree, okay, and I went and took the bar examination. After I passed the bar, lawyers say they never passed a bar after that. After you pass the bar means I'm licensed to practice law. If you do not have a law license, you can't give and charge for legal advice. So, and same with doctors and nurses and other professionals. So if you're doing that work and you don't have the license, your agreements are void. Covenants not to compete. I ask a lot about this. Covenants not to compete are legal if reasonable in scope. What does scope mean? Go back to tort law. It means breadth, what the heck are you doing? Time, when are you doing it? And distance, where are you doing it? You need to know that. Okie dokie. Lastly but not leastly in this chapter is usury. Now, here's where you need to wake up. I talk about usury, and that's a charging of an illegal interest rate on a consumer transaction, and I distinguish between that and the time-price differential, where it costs you more money over time as opposed to a cash price. Both of those are on this test. Take your time. The test is of about equal difficulty as the first test. Take your time. Do not speed through it. Good luck.